Rejected. Dismissed. Yes.
In this case, Lordship, the petitioner is in custody since 1 year, 11 months, and 18 days, Lordship.
Charge sheeted case.
Charge sheeted case, Lordship. 1 year, 11 months, 18 days. The petitioner was arrested on 20/12/2022.
What is the status of the trial?
Witnesses have been examined.
How many witnesses?
8.
When the charge was framed?
Charge was framed on Lordship 30/7/2024. Charge sheet was submitted on 30/04/23, 30th of April 23. On 25/2023, cognizance of offense was taken. On 30/7/2024, charges were framed.
When were you arrested?
I was arrested on Lordship 20/12/2022.
Maybe once in Malot 25, let's Malot call the scan copy of the LCR.
Lordship, here, along with the petitioners, 3 other persons were arrested, Lordship. One of them was Lordship Zamiruddin. On 11/11/2024, Lordship was pleased to grant him bail, Lordship.
On
That
pro-
order I have the next and case number 90. 95, paragraph number 1222 may be perused, Lordship. It also appears from the record that next date before the learned trial court is fixed on 28/1/2025. Under such circumstances, it is unlikely that the trial would culminate at the earliest, and this court is of considered opinion that the incarceration undergone by the present petitioner in the present case would be regarded as long enough to override the above section 37 of NPPS. Therefore, court is considered opinion that the petitioner is entitled to arrested along with the petitioner. Same forwarding report.
My lord, this earlier order that is my lord passed on 11/11/2024. And my lord was pleased to grant the bail, my lord, after producing the my lord scan stated in the para 13. Para 13, I have considered the submission made by the learned counsel for both the sides and have produced the materials available on record, including the scan copy of special NDPS case such and such. It was requisition from the trial. My lord, because my lord, we have to control whether they are in the same footing or not. Oh, my lord.
They are on the same footing on one count. On one count that he has been incarcerated. Let us still call for the scan copy.
Any date before the petition.
Yes. Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Bush, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner, namely Jubair Ahmed, who has been detained behind the bars since 2012-2022, within bracket more than 1 year, 11 months, or more than 1 year, 11 months. Stop. No stop. In connection with Special NDPS case number 170/2022. Top learned counsel for the petitioner has submitted that one of the co-accused, namely Jamir Uddin, who stands on the same footing as that of the present petitioner, has already been granted bail by this court by order dated 11/11/2024 in bail application number 2662/2024. Hence, he also prays for grant of bail on the same grounds. But on the other hand, London additional public prosecutor submits that as to whether the present petitioner stands on the same footing like that of the co-accused who has already been granted bail or not can be ascertained only after perusal of the scanned copy of the case record. Hence, same may be perused. Considering the submissions made by learned counsel for both the sides, this court is of opinion that perusal of the scanned copy of the case record of special NDPS case number 170/2022 would be necessary. Hence, call for the same from the concerned court. Let yes, we still again on 19th of December.
File please.
Wait, this is the lordship. Lordship, this is an anticipated bail application, lordship. Here, FIR lordship will find on page 14, lordship. Since in the FIR, husband has been shown as an absconder, lordship, now police is after this petitioner, lordship, as an absconder, though recovery has been shown.
What
From
is
the-
the offense?
Lordship is 21B, lordship, NDPS Act, lordship.
21B.
Yes, lordship, but as
Is there?
No, my lord, this is the first time, my lord, motion states.
It is a
Call for this.
case under investigation.
yes, probably, lordship, but the actual recovery was, lordship, as per the co-accused bail order, lordship, it is 2.8 gram, lordship.
2.28 gram.
Yes, lordship, page 18 is the bail order of the wife of this petitioner. And paragraph 5 on page 20, lordship, it's a lordship order, lordship.
You are the husband.
Yes, lordship, husband has been shown as an absconder in the FIR, lordship.
Where is the FIR?
FIR that is on page 14, lordship. They have stated a husband has dealing with illegal narcotics, drug and psychotropic substance, but so no previous case has been shown mentioned in the FIR, lordship.
What is the recovery? Where is?
Recovery that is they said lordship 20 gram, but the actual recovery was only 2.28. That is on page 20, lordship.
Where is 20 gram?
That in the FIR, lordship, middle part, lordship.
During house search, my lord,
Lordship is 1, 2, 3, 4, 5, 6, 7.
before that,
6 line from the paragraph number 2, lordship, in page 14, lordship.
Then case diary would be released.
And lordship, kindly lordship peruse the lordship order that is on page 18, lordship.
No, but that was with regard to the wife.
Yes, lordship, there's what is the actual recovery, lordship? Page 18 and relevant portion on page 20, paragraph 5, lordship.
Here, my lord, in the para 5, my lord, of the page 20, my lord, of the order. That clearly states that, my lord. That is it appears that the allegation in the FIR was mainly against the husband of the present petitioner, though the petitioner also reside the same house from where the recovery has
Okay,
been
no,
made.
let us, we have to.
The recovery, now
Moreover,
read
the
the,
recovery
moreover,
is-
the recovery is only
Which is
2.28 gram, 28 gram.
My lord.
That is the specific, what is the recovery has been made. I am not that lordship, not calling for the LCR, I am not that lordship. Recovery is only 2.28 gram.
Whether charge sheet has been laid? No.
That instruction. Lordship,
This,
lordship,
this
charge sheet
is
has not been, laid,
at the
lordship.
stage of investigation.
Yes, lordship.
We will peruse the case then.
Yes, lordship. But recovery is 2.28 gram.
Okay, let us-
Now, lordship, may I take lordship, and the coordinate bench judgment that is on page, order lordship, that is on page 22, lordship. Where it was considered lordship is an bailable one, lordship.
Then the anticipated bail is not maintainable.
But
If
this,
you-
this, whether lordship will appreciate this, and peruse this order lordship on page 22.
Then should we go by that? Then you withdraw your,
Let the case diary be called for lordship. Since it is not related to this case, but in the court coordinate bench has observed that in other case lordship, 3.25, that time it was recovered only 3.58 gram loss.
no, if it is bailable, if it is held to be bailable by a coordinate bench, then your this application is not maintainable.
That lordship, since lordship, this case lordship, 20 now 2.28 gram.
Yes, whether it is
That's why
20 or
case diary.
heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bashaw, K. Bashaw, learned additional public prosecutor. Considering the nature of allegation leveled in the FIR, perusal of the case diary is felt necessary for consideration of the instant bail application. Hence, call for the same. Let the case be, this case be listed again on
My lord, 19th, my lord.
Can
Nine-
it be on 18 or 17?
18 12 for case diary.
Can it be 17 lordship? Possibly, possibly. 7.
17,
7.
17, 12.
I live this.
May I please know, when our senior counsel, Mr. D Das is out of station. may I please know?
Item number 4. You are appearing for, Mr. Das is appearing for respondent number 2. Yes,
It's a very old man.
yes. When can we fix it?
Instruction.
Then we will hear it if you don't have any instruction. You have to suggest a date if you are paying for adjournment. When would the council would be available? Only you know. We don't know anything.
Also, I am not in the-
What to do
Next week.
next week? Heard. Miss P. Barua, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Your state is a party?
Yes, my lord, state is respondent number 1. my lord.
Yes. Miss, what is your name? Miss B. Soikia, learned. Miss P. Soikia, learned counsel for the respondent number 2. Learned counsel submitting on behalf of Mr. D. Das, learned senior counsel who is appearing for respondent number 2. Submits that praise for an adjournment as the conducting counsel for respondent number 2 is out of station. Considering the submissions made by learned counsel, the prayer is allowed. let this matter be listed.
Friday next. Lordship. 13th.
On 13th December 2024.
No further adjournment, Lordship, because it's a very old 2014 matter, Lordship.
On 13th, you don't concede to their prayer. If they,
Lordship, I was not informed, Lordship. In fact.
But-
just-
today you have not opposed,
I can, Lordship, I'm ready with my arguments, Lordship.
but I have already passed my orders.
Lordship, Friday, Lordship, for final discussion.
Okay.
This is subsequent application, my lord. And earlier, my lord, petition was rejected on 26/6/2024. I am, my lord, on behind the bars, my lord, since.
Ms. Brown, you have received the papers. You are ready?
My lord, I am behind the bars for, my lord, 17 months, 2 days, my lord. And 40 witnesses have been, my lord, listed, my lord, in the charge sheet, my lord. And out of them, my lord, 7 already have been examined, my lord, prime witnesses, my lord. An earlier petition was rejected on the ground that, my lord, kindly turn to page,
When were you arrested?
my lord, on 4/7/2023, 17 months, 2 days, my lord. And main ground, my lord, was, my lord, because my lord, my earlier prayer was rejected, that, my lord, one Mubasira Khatun and
Where is,
Jahangir Alam.
where is the earlier rejection order?
Page, my lord, 68, my lord.
Relevant part is page 70, my lord.
Page 70,
Para
my lord. Page 70, my lord, relevant part, my lord. It was, my lord.
What is 376 DA?
My lord, allegation of gang rape also, my lord.
Okay.
Mubasira Khatun and Jahangir Alam. They, my lord, they are prime witnesses as alleged, my lord. They were not examined. That is why my earlier prayer was rejected. But, my lord, Mubasira Khatun already has been examined.
And
And
Jahangir Alam?
And Jahangir Alam, my lord, notice someone has been issued, but he is not turning up the court, my lord. That is why he has not been
Then-
examined.
He has to be examined.
But, my lord, kindly turn to this, my lord, on 17/8/2024, last, my lord, Abdul Razzaq was examined. 17/8/2024. Thereafter, my lord, no witnesses examined.
No, but once your prayer was rejected on a specific ground, that 2 witnesses who are named in the
That is true,
order
my lord. But
are not.
Mubasira already has been examined, my lord. But Mubasira, my lord, other prime witnesses are examined, my lord. But he has not turned up the court, my lord, due to, my lord, already, my lord, someone has been issued, my lord. I am, my lord, detaining, my lord. And, my lord, 40 witnesses are there, my lord. So
No,
is the time.
40 are not, may not be so relevant for bail.
only 7 have been, my lord, examined, my lord.
As specific mention about two names have been mentioned.
That is true.
So
my lord,
at
but
least
he has not
Jahangir
turned-
has to be examined.
He has not turned up, my lord. That is the, my lord, burden on the part of the prosecution, my lord. And your lordships knows, my lord, Satendra Kumar, until 39 para and 1, my lord. If long, my lord, if the trial is delay, my lord.
Why Jahangir is important?
No, my lord, he is not important, my understanding, my lord. Mubasira is important, my lord. And other person, my lord, Anwar Hussain, he is the informant, my lord, father of the daughter, 39 para 49 1, my lord.
When is the next date fixed before the trial court?
My lord, I have to check out, my lord, I have no instruction, my lord. And, my lord, till 17/8.
What is your
2024.
submission?
And LCR, my lord, that is the orders that I was not able to go through, my lord. But other than that, my lord, that is an important, my lord, part because, my lord, that is Jahangir Alam, my lord. So the incident took place in a, my lord, youth field, my lord. The allegation is that these are the person after rescuing that girl, resist. And the other.
Girl has died.
Yes,
Yes,
suicide.
my lord,
Committed
in
suicide.
direct implication, my lord, may kindly see the PW2, my lord, PW2, they're the colleague, my fellow girls, those who were there, my lord. He listed it, my lord, who said the PW2. And it is a sufficiently in progress, my lord. It's not that, that is not progressing, my lord.
But my lord,
Clearly indicate, my lord, may kindly see that is in the page number 37 of the, my lord, that is the
How many accused are there?
the accused,
What happened to other two?
my lord, my lord, all are facing trial, my lord.
They are also under detention.
Yes, my lord, detention, my lord, and as per FIR, my lord, I am not at all involved, my lord. Accused number one, Zahirul Islam, he is involved as per FIR, my lord. Direct allegation, my lord, against him, my lord. But in charge sheet, my lord, is different, my lord. So contradiction is there, my lord. And father lost the FIR, my lord, after committing suicide of his daughter, my lord.
Yes, what you have to say.
Question is that this Jahangir Alam needs to be examined because he's one of the vital witnesses, also as per my understanding of it.
Okay, then we will call for a report
My lord.
as to whether he has been examined or not.
My lord.
From the trial court.
My lord.
What is the status of the trial as regards the summons issued to Jahangir Alam? Because there is an observation made by this court that Jahangir Alam is a vital witness. Heard Mr. S.H. Sigdar, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor, as well as Ms. M.K. Brown, appearing, learned amicus curiae, appearing for respondent number 2. During the course of hearing, it transpired that the earlier bail application filed by the present petitioner was rejected on 26/6/2024. Stop. At the time of rejection of the said bail application, an observation was made by this court that two material witnesses, namely Mubasira Khatun as well as one Jahangir Alam, are required to be examined before the petitioner is released on bail so as to ensure fair trial of in the case. Stop. It is submitted by learned counsel for the petitioner that in the meanwhile, Mubashira Khatun has already been examined and the trial court has issued summons to Jahangir Alam. Stop. In light of the submissions made by the counsel, let a report be called for from the trial court as to the status of the present status of the trial and as to whether Jahangir Alam has been examined as prosecution witness or not, and if not, what has been done in this regard. Stop. The report may reach this court before the next date fix. Let this case be listed. When is the date fixed before the trial court? You are not aware. Then we will fix it in the first week of January. Because if we don't know whether the case is listed, well, you are also unaware. 6th of January. 5th is Sunday. 3rd of January.
Your lordship. We have been granted interim and we appeared lordship. Lordship of co-accused was also given absolute bail lordship. That is in page number lordship. We have.
Case diary is there.
My lord, here in this matter, my lord, earlier the matter was from the, my lord, Palpanbuda police station. My lord, thereafter they, my lord, sent it to Nunmati police station. My lord, we get a report from Nunmati police station. My lord,
Charge sheet has submitted. Regarding whether they have appeared or not, you don't have any
my
information.
lord.
But lordship, as per the FIR, our name has not been implicated in specific allegation against one Sri concussion. Lordship. Peruses the FIR, we have not been implicated in any way, Lordship.
No, whether charge sheet has been laid against you or not.
That is,
Against whom charge sheet has been submitted?
That would be very matter. But that is
Now
not
what is to be
available,
done?
because in the FIR, there is no
What is your submission?
submissions. That if my name is not implicated in the charge sheet, I may be granted absolute bail, Lordship, anticipatory.
And if it is in
then
there,
required. Because already interim granted and we had appeared, Lordship, as per the honorable court's direction.
heard Mr. B. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 2/9/2024, when you were granted interim,
22/7, Lordship, the month of July.
by order dated 22/7/2024, the petitioner, namely, what is your name?
Sanju Kumar Chetri.
Sanju Kumar Chetri, was allowed to go on interim bail by this court on certain conditions. Learned counsel for the petitioner has submitted that the petitioner has appeared before the investigating officer in pursuant to the directions of this court and has cooperated in the investigation. On the other hand, learned additional public prosecutor has submitted that in the though the case diary was called for in this case, however, in the meanwhile, charge sheet has been laid bearing charge sheet number 119/24 dated 28/2024. However, learned additional public prosecutor could not inform as to whether charge sheet has been laid against the present petitioner or not. Be that as it may, in view of the submissions made by learned counsel for the petitioner that the petitioner has appeared before the investigating officer and has cooperated in the investigation, the interim anticipatory bail granted to the above named petitioner by order dated 22/7/2024 is hereby made absolute, with condition number 2 remaining attached to the said order remaining intact. Further, if the petitioner has been named in the charge sheet, he shall also cooperate in the trial. With above observation, this bail application is disposed.
Deeply obliged. Obliged.
Yes, please, your lordship. My lord, in this case, as this honorable court may recall, my lord had directed an inquiry which has been conducted and a report has been filed. The report supports the allegations that I made so far as the facts are concerned. But it came to a different conclusion though. In this case, my lord, if I may say, it's an admitted fact and as it is also projected in the inquiry report that they had received 9 sheets of the FIR and they had annexed 8 sheets in the FIR. I do not know whether there's a video recording, my lord, when the bail was moved. This honorable court had made this statement, my lord, that it was because of that sentence that was there as the previous page was missing, and that is why this honorable court has granted interim bail, else it would not have granted. Be that as it may, my lord, I am not really on whether bail should have been granted or bail should be cancelled. I'm not on this, my lord. I'm on a more higher platform, my lord. This is a case which perhaps should be a whistleblower, my lord. If we have taken an FIR and it is based on that FIR, we file an application, we have no reason that we do not submit the total certified copy which has been obtained by us. Secondly, my lord, when the paper missing materially transforms the information that was in the document, my lord, that, my lord, in my respectful submission, and a conclusion or that can be drawn is only that it was materially affected to get benefit out of that. We may call it.
No, I'm not getting you. Whether it would amount to willful suppression of facts. Your submission is, had the document which was missing been there, the decision would have been different.
Perhaps, my
The- the-
perhaps, because it materially, instead of saying,
Now, what is your prayer?
here is that, let this be a whistleblower, it is for us, not only for the other side. It is
You
not the
need
lawyers.
certain directions to be issued by this court.
By this honorable court to cause, let there be an FIR registered, my lord. Or my lord, let there be some investigation done as to what went in, not the complete FIR being.
Have you gone through the inquiry report?
Yes, my lord, the inquiry supports what I have said, my lord.
No.
Let me show, my lord. I will show, my lord, from the inquiry report,
I have not gone through it.
my lord, I will show.
Now, what is the,
In the
Well-
third subpara, my lord.
no, what is the recommendation? Whether inquiry report makes some findings, what findings it arrived at?
The findings that it has arrived at is that they had got 9 sheets, 9 pages of the FIR. And this finding is also there that they had annexed 8 sheets in the FIR. Which sheet is missing or which page is missing, that the inquiry report does not state, but it categorically states on their own admission that they were given 9 sheets of the FIR. And also this fact is, from the third subpara, my lord, let me place it, my lord. In IA criminal, may I read it, my lord?
Yes.
In IA criminal number 779, 2024, the learned counsel for the applicant submitted that the respondent, Sri Madhurya Das, had filed AB number so-and-so by annexing a tempered copy of the said FIR, thereby intentionally misleading the court. On the other hand, my lord, this is important. On the other hand, the learned counsel for the respondent submitted that when they applied for the certified copy of the FIR, they were provided with a certified copy which contained only 9 pages. The Honorable Court by order dated such and such on perusal of the copy of the FIR annexed with AB 1152, it appeared that page number 4 of the FIR was missing. Considering the allegations leveled by the applicant regarding the intentional use of a tampered document, the Honorable Court directed the undersigned to conduct an inquiry and submit a report regarding the veracity of the allegation intentionally annexing tampered copy of the FIR with AB number 1152. Meanwhile, in IA number 778, learned counsel for the applicant submitted that the respondents, with Sri so-and-so and so-and-so, had deliberately misled the court by annexing a tampered copy of the above named FIR with the anticipatory bail application number so-and-so, thereby interfering with the course of justice. It was also submitted that in a similar matter, with similar facts, one of the co-accused, Sri Madhurya Das, had used a tampered document, and the Honorable Court, by order dated 2/9 so-and-so, had directed an inquiry to be conducted. That was even before we appeared, my lord. This Honorable Court had already directed an inquiry to be conducted, and therefore a similar inquiry was required. Sorry, this is the same inquiry, madam. I'm sorry. A similar inquiry was required to be conducted into this matter to find out whether there was an intentional use of a tampered document for the purpose of obtaining bail by the respondents, with so-and-so. Whereupon the Honorable Court, by order dated 9/9/2024, directed the undersigned to include within the purview the second one. I'm skipping this. In terms of the order dated 2/9/24, next para, my lord, the CJM Kamrup was requested to direct in charge the letter of the CJM. And then I'm skipping this, my lord.
No,
Now-
what was the finding? He was asked to find out whether,
Now, my lord, if we go to the seventh page, let us go to the seventh page. From the above, it can be concluded that my lord has got it.
no, I'm listening, I'm not going through. You do.
From the above, it can be concluded that the copying branch of the establishment of the CJM Kamrup Metro had committed the error by furnishing an incomplete certified copy of the FIR Bhangagar PS consisting of 9 pages instead of 10 pages to advocate so and so. It is also evident that learned advocate so and so did not cross-check verify the actual pages of the FIR of Bhangagar PS case number at the time of filing AB number so and so and so and so. In other words, it appears that the advocate had failed to take proper care and caution while filing the bail applications. Next, that apart the certified copy of the FIR of Bhangagar PS annexed with AB number so and so consists of 7 pages instead of 10 pages, and it is admitted that they got 9 pages. And they have annexed 7 pages instead of 10 pages. However, the Honorable Court in its order dated 2/9/2024 passed in IA number 779 did not mention anything in this regard except that the certified copy was missing number page 4 of the copy of the FIR. It, my lord, so far as the inquiry officer is concerned, it did not really get into all the facts that 9 pages were given. They annexed 7 pages on the ground that this Honorable Court mentioned only about page 4.
Okay. Then what it held, it came, what finding it came to?
Acha. These are the findings, my lord, that I'm reading. Not the conclusion, my lord. I'm reading the findings. However, the copies of the FIR annexed with both the real petitions do not bear any signs indicating of overwriting, erasing, etc. My lord, in my respectful submission, let me complete this. I have tallied each and every page of the copy of the FIR annexed with the bail application with that of the original application. FIR submitted by GR, copying branch of establishment of CJM Kamrup. And I find that no changes were made. My lord, it is not that in a page I make erasure or tampering. That is not only the change. If I remove one whole page, that is pure erasement of the whole page, my lord.
That was not taken into
That is
consideration.
not taken into consideration. And my lord, one thing, my lord, I'm not actually on the cancellation of bail. One thing is that, my lord, it's a serious issue. Let this not go just like that.
Now, what is your suggestions?
My
Make-
suggestion is it can be two alternative, not two alternative. About the bail cancellation or not cancellation, I'm not saying anything. I leave it to this Honorable Court. But my prayer here is on the basis of this, either a proper inquiry be conducted.
Again, an inquiry.
Alternative. That is not actually my first choice. But I'm giving the option since this Honorable Court is putting on.
Yes,
me.
yes.
Taking into consideration all relevant facts that appear from the complaint. And secondly, my lord, and in fact, that should be firstly from my side, let there be an criminal complaint lodged to my lord, it is not maybe the lawyer. So far as that time from 10 pages, it came to 9 pages. That time perhaps lawyer was not involved. Who was involved? Something has happened which is missing our eyes, my lord. And thereafter, after that 9 pages, it comes to 7 pages, it comes to 8 pages, and up to 7 or 6 pages. And in the trial court, my lord, they find only 6 pages, and they got an order in our absence, of course, that all money, my lord, has been released, my lord. And even the IO gives a report that it is not required for investigation, although the whole complaint is based on that bank account and that fund. If something has happened, my lord, which is missing our eyes, and therefore I pray before this Honorable Court, since at least this is a part of the judicial proceeding which this Honorable Court had, my lord, was taken by this Honorable Court, let there be some direction, my lord. We will also be careful, not only the other side, we will also be careful.
Okay. What is your submission? How much time will you take?
10 minutes, Lordship.
Or we'll meet at 2. I have a meeting.
That
Again, we'll sit.
I'm grateful.
What is your name? P. Chaudhary. Mr. D. Das is appearing in this case.
He does will appear on paper.
Okay.
He is a
Yes, Mr. Khan.
Upon Lordship, so far the inquiry report is concerned. Inquiry report, whatever Lordship we have submitted, that 9 pages were supplied to us by the opening section of the CGM. Accordingly, the Lordship record is saying so. That page number 7, in fact, Lordship, that was the part of the FIR. That page number 7 of the FIR, that was the part of the FIR, but there was no pagination in the FIR. And the last line of page 6 and first line of page 8 is also missing. But we have no intention to that the one page was not there, and even after knowing that, we have filed this petition. And secondly, Lordship, the FIR copy given to us, Lordship, that consisting of only 9 pages, except one page, page number 7. And so far, page number 2 and 3, Lordship, we have not annexed with the bill of lading, because these 2-3 pages, Lordship, not relevant pages. Because relevant pages start from Lordship page 3, that is from the first page of their FIR, Lordship. Lordship, may I submit?
No, you may submit that whether you have by submitting the FIR with 1 page short or 2 page short,
Yes.
whether it was intentional or whether
Absolutely not.
whether an offense has been committed calling for lodging of FIR as has been prayed by.
That is the
That is the prayer.
Somehow my friend is trying to, Lordship, involve our rule also.
No, you have to counter that. To counter that, facts are regarding the facts. An inquiry committee was constituted. They have already,
Findings
No.
have been made.
so
Findings has already been made. Lordship, that is the based on the record. The findings is very much clear. There was no intention from our side, Lordship, from the advocate sides or from my client side, Lordship, had any intention to get any benefit by missing 1 page, Lordship. That is,
No.
I am also admitting that was the vital page. But that page was not supplied to us. We have, Lordship, 9
but
pages supplied.
you being an officer of the court, you should have verified it before submitting it
Yes, Lordship.
as an annexure.
But FIR is concerned, that's what the final I have already submitted. There was no pagination in that. If there could have a pagination, that even that some negligence on our part that can be established. But in the FIR, there was no pagination. There is no pagination. Secondly, Lordship, last line of the page 6 and first line of the page 8, in between these 2 page 7, Lordship also missing. No one can detect that some 1 page is missing.
What is missing?
Page number 7,
Yes.
that is the FIR, Lordship, contents of the main FIR. Lordship, last line of page number 6 and first line of the page number 8.
Is also missing.
No. Is also, yes, Lordship, is also missing.
Therefore, you could not tally
Yes,
whether there is continuity.
detect that some 1 page is missing from here. Your Lordship has had also gone again and again to that point. My friend Lordship, he was raised during the bail hearing, and that was also recorded by your Lordship, that part. That there was, it appears that there was some
veracity in the FIR that was also directed to verify by the PP. But on the my friend was there. My friend also, Lordship, did not raise any objection to that effect. That was pointed out by my friend Lordship Lanet PP. I also admitted that it appears, but as nobody was raised, record did not Lordship saying anything. Lordship, we had no option.
Okay. Okay, I'll go through you have anything?
Well, to add to that fact, to add to what my learned friend has said, my lord, I just point out which pages. It is not that simple, my lord. Otherwise, even I would have taken it that it must have been unintentional, and but that it is intentional. It is very explicit from the pages that are missing. In our IA 779, my lord, I will just show which pages are missing. Page 11 is the FIR, my lord. This 11 starts, my lord. Can I be assisted? Page number 12 is missing. That is the second page of the form. I'm giving the certified copy so that the honorable court has this can see the contents, my lord. At serial number 12, my lord, serial number 12, the gist of the FIR is always recorded by the IO in the second page of the form. This page is missing. Then again,
No, where it is missing? Page 12, it is there.
it is there. This is my IA.
Okay,
This page was missing in the bail application. That clause 12, which is very relevant part of the FIR. And then page number 17 is missing. Now, what my learned friend is trying to make out, I also tried to see whether if I am a lawyer and there is some genuine mistake, whether this can happen. Now, my lord may read page number 16 and 18, and let us see whether there is
page number 16 and 18. No?
because 17 was missing. And he's trying to make out a case that 16 and 18 is in such a sequence that it was difficult for him to make out that one page is missing. If we read 16, last sentence, considering the same.
He's saying that last sentence was missing.
No, he's saying that page 17 is missing, that he's admitting. But he's saying that page number 16 and 18 was in such a sequence that he could not make out that one page is missing.
No, last line of page 16 and
Not saying that last line was missing. And you are saying that last line of the page 16 and first line of the page 18 is also missing, not missing.
Matching.
matching. Okay,
Lordship, that was.
That is what say, instead of this confusion, I use the word sequence.
okay.
Now, page 16, I made it because I remember reading my FIR, and when I was moving the IA, this honorable court was saying something else and I was reading something else. And that is how when after the matter got over, I said I was reading my FIR and this honorable court was not taking it because the honorable court had their FIR. Now see, considering the same, page 16, last sentence, considering the same, I the undersigned, RG Barua Road. Can it be I the undersigned RG Barua Road? It cannot be. And in Madhujada's case, from that order, this paragraph 10, my lord, this honorable court had said, while granting the bail, on the other hand, learned additional public prosecutor has pointed out certain discrepancies in the copy of the FIR annexed with the bail petition. It was pointed out by the public prosecutor. And had submitted the perusal of the case diary would be necessary. And when the diary came and we also came, then this honorable court went by their FIR, and this honorable court very specifically stated that it was because of this page 16 last sentence and page 18 first sentence, this honorable court had granted interim to them. And but my lord,
Whether interim has been made absolute.
my lord, it was made absolute, but I'm not on the whether bail was granted or not granted. Whether it should be granted, should be cancelled, I'm not on.
That is not the prayer.
That is
There
not
was
my prayer. That is not my prayer. Let me point out here. Then the one the sequence does not match. This honorable court while granting interim also record this fact, and this FIR was not given absolute minority, it was rejected later. In this order, this honorable court pointed out, recorded that it was pointed out by the public prosecutor that there is some discrepancy in the FIR. It was pointed out, but even then, and so far as the page number is concerned, the page number page number 14, at page number 14 of my application, if this honorable court says, sees, or may take the original FIR also, perhaps it will give you a better copy. Where the Tinsukia pin number is given, there is page number one printed. And my learned friend may not say we did not see. Because if I am seeing, he also could see, and then he got 9 pages, he submitted only, he furnished only 7 pages before this honorable court. And then the where Tinsukia pin number is given, my lord, at the footnote of the page, footnote, my lord, before that underline. Tinsukia 786146, that there is one printed,
Over one.
yes, over one. And then on page 15, then after that pin number, that page number 2 is printed.
There is overlapping of,
My lord, I could see it, my lord. I
I-
could see it. And I did not take any magnifying glass.
no, if somebody points out, it can be seen.
Yeah, my lord, I
No.
pointed out myself.
Otherwise,
I pointed out, not otherwise, my lord. This is one factor which I'm pointing out because he is taking this plea. Otherwise, for me, this is not important. Then page 16, that's page number 3. Then page 17, page number 4, which was missing. Now, this point I did not raise because the printing is so small, there is a possibility that one may miss. But coupled with the fact that contents of page number 16 and page number 18 was not in sequence. Secondly, and more importantly, they were given 9 pages. They have filed only 7 sheets of the FIR. And in the second form, where the gist of the FIR is mentioned by the IO, even that was also suppressed. My lord, whether these facts do not reasonably conclude that it was intentional. And the lawyer is same for that, that bail petition wherein this honorable court had recorded the objection raised by the APP that there appears to be discrepancies in the FIR. My lord, all these facts, my lord, they very glaringly show.
Okay, I'll go into it.
I leave it to my lord. I leave it to my.
Mr. Bosho, you have any submission?
You made a submission there.
This is the order.
Recorded. The party is recorded.
Para 10.
Now, assuming that there is I'll go into the everything. Now, what is your submission?
My submission is on the part because my the inquiry is made by. Some findings, my.
No, what I am seeking from you is that petitioner's counsel has suggested, made submission that FIR should be lodged. Or in alternative, certain directions should be issued. Main prayer is that FIR should be lodged. The counsel for the other side has said that this is not intentional, not makes out a case for lodging of FIR. What is your submission on that? Assuming that there are discrepancies in the photocopy submitted along with the bail application, it does not tally with the original FIR. So what should the court do? Or you can leave it on court. That is the best option for you. Okay.
Just one. This is the original FIR that we had here. Your Lordship, the two page my friend is saying again and again, page number 2 and 3, some substance has been recorded. My lord is in this High Court lawsuit, most of the advocate lawsuit we have found.
I do not do
They-
it, my lord.
let
What
me
he's
say- let-
suggesting,
let-
I do
let-
not do it.
Let him.
She may not do. But these 2 pages, 3 pages are not relevant because the main part start from their own FIR,
Written up.
written FIR. Because whatever written in this here, these are not vital for adjudication of the bail petition. Your lawsuit is very much, I think your lawsuit never go.
Therefore, you intentionally did not give that format.
This format is not necessary in my view lawsuit. Because these 2 pages normally lawsuit are, this, if we, this, give these 2 pages, every FIR lawsuit we have to type the entire FIR. We have to type because the lawsuit, your lawsuit may kindly verify this.
Okay,
first,
no,
second, and third.
I got your point.
Not for the purpose of this case, my lord, but I'm just
Whether
saying
it is
my young
necessary.
friend also will perhaps will get another perception of the whole matter. On the basis of the 2 forms, what is recorded by the police in the 2 forms. Trial matters, when we come up in appeal, that is really a big base for us. And on the basis of that, we have set aside, we have persuaded the honorable court to reverse convictions on the basis of that. And my friend saying that he may be doing or not doing, my lord, the fact remains, and it is a finding of the inquiry in the inquiry report also, that those pages were missing. And that page missing, only that conclusion that came, perhaps is my respectful submission is not a correct view, that it cannot be said to be erased or tampered when the whole page is gone. That means we can do that. If that is the, that is what. And I leave it, my lord, it is for the institution, my lord. If this honorable court thinks that something should be ordered, the institution will be safer, my lord. And if it considers otherwise, I have got nothing to say, my lord.
As far 7 number page is concerned, this is otherwise a vital page. That was not supplied to us.
Okay.
That has been recorded in the inquiry report itself. They are saying that there was an error on their part to supply all this paper. All this page, only 9
Not
pages
only,
were
only this page, out of 10 pages, they admit that they got 9 pages.
No, we are
And
not
they
saying that
furnish
we have
7
got
pages.
9 pages. We are saying that we have got
Yes,
9
that
pages.
is what. Let the facts remain clear. and there are-
Heard Miss B. S. Goyal, learned counsel for applicant in both the cases, in separate order. Learned counsel for the applicant. Also heard Mr. K. Busho, learned additional public prosecutor, as well as Mr. M. Khan, appearing for the petitioner. AB case number 8. Dota के सब बेले बेले के भी हों. AB case number 892/2024. And pass orders on some other day. Let this case be listed for delivery of orders on 19th December.
Something is recorded that certified copy, this honorable court may retain it, but it may be returned after when the order is passed. Because the trial court has stopped issuing any certified copies in this case anymore. So
Certified copy of
that certified copy which I produced, let it remain because the contents are very visible, my lord. In the photocopy, it is not
This
that
one?
visible. Yes,
no, you get it photocopied.
I did photocopy and I have already, a part of the record, I have already annexed it.
Both the
annexed it.
FIR
Page 11, 12, 13, it is already there, but it is more visible in this.
This is for what purpose?
This is
For
only-
the missing pages are there,
No, the missing pages are in the photocopy also I have supplied.
but
Only
it is,
the contents in the form is more visible. That clause 12 that I pointed out in the 2nd page and the 3rd page. The FIR story is always there in the form. This form is not just an idle exercise. It's a very, very
a
important part of the
certified
FIR.
copy of the certified copies furnished by the learned counsel for applicants today in the court shall be retained with the case record. Same shall be returned back at the time of delivery of final order to the learned council.
But here I'm praying for all of Lordship's order, page 70. This submission which was made by me that there is no surviving cause of action. It was based on a misinformation which has been taken from the e-code status. Your Lordship will find the e-code status as.
What is this? This is an interlocutory application.
Kindly see page 17 for a moment.
Now, what you are praying in this interlocutory application?
Recall of this order dated 31/7 and restoration of this civil revision. This revision was disposed on a submission made by me that there is no surviving cause of action. So what happened, my lord, here? My lord, the council along with me, who was on record, he died on 18/8/2022. He was very much in contact with the clients, my lord. On the date when the matter was listed, I tried to find out from the e-code, my lord, the e-code status your lordship will find at page 15, my lord.
No, at what stage it was disposed of?
My lord, admission stage. Admission
Whether
stage.
notices were
Notice
issued?
was not served, notice service was not completed. There was a stay order operating. The proceeding before the trial court was stayed by this honorable court on 18/11/2016. The matter came up before this honorable court. On that day, my lord, I made a submission that there is no surviving cause of action. Because in the e-code status of the title suit, my lord, the original suit,
No, whether notices were issued
my lord, in this application,
in this application?
No,
Not
because-
in this application.
in this CRP notice was issued, but the service was not completed. None appeared for the respondent. But I made a submission that there is no surviving cause action, and on that ground, the CRP was closed. But my submission is based on a misinformation that is taken from the
Then we'll issue notice in this case. Because
in the, but what I suggest, my lord, if your lordship restores the CRP, in the CRP main, my lord will issue notice because they will have a saying
where is the CRP?
CRP, it is disposed, my lord, it's along with the record.
Now, put on.
Their service was not completed. We were supposed to take fresh steps, my lord.
Now, what is your submission?
My lord, here, my lord, will kindly see the in the IML of page 17. my lord. This order which I am praying for recalling, my lord, and restoring the CRP to its file. Page 17. My lord, is in page 17. Here, my lord, on my submission, my lord, the revision was declared to be
No,
infraction.
but under what provision you are making this
My lord,
application?
I'm making this under 151. Because apparently, my lord, the page 15, if your lordship kindly see page 15 for a moment.
Yes,
Page 15, my lord will see
page 15.
page 15. My submission was based on page 15, my lord.
Yes,
Page 15, your lordship will, from the bottom, my lord, the lordship will see 7/17/2017. The matter is shown to be disposed. The title suit was shown to be disposed.
yes.
And therefore, my lord, I made a submission that there is no surviving cause of action because the order which was put to challenge before this honorable court, if the title suit is itself disposed, then nothing will be decided. And now, my lord, page 19, my lord, you kindly see. After the matter was disposed, the LCR was sent back to the Planet Trial Court, my lord. Page 18, a notice was issued to the petitioner, my lord. They came to know on page 18 after receiving the summons. Now, page 19 is a communication from the petitioner to me, my lord, where my lord will kindly find in the third paragraph, my lord.
Yes.
that some communication gap arises, we inform to claim that not settled involved in this matter and still we recover the amount from party on account of bank guarantee. Our local council in Tezpur also not update about the matter on 18/9/2021. Last in 2017, the local council in Tezpur informed us that the matter is disposed of and nothing is pending. We came to know about this matter when the court notice received in our company. So basically, on the misinformation, my lord, the matter was closed as infractions. However, the matter is still surviving. My lord, there was a stay order operating.
No, but it was on your application.
Absolutely, my lord. My lord, that I tender my apology, my lord, because my
No,
my
but
submission,
tendering apology, then there will be no end to it.
my lord, my submission is based on a misinformation that is from the e-code status of the official website. Where it is page 15, my lord, will kindly see. That's the last status of the case record.
Now, have you verified how it was revoked again?
No, my lord, revocation is next, my lord. When we got a printout, this is subsequent, my lord. This printout, your lordship will find,
Actually, what happened on 7/1/2017? Have you verified?
my lord, it
That
was
has to
shown-
be verified,
but it was shown as disposed.
whether it was actually disposed of.
But
Why?
the e-code says so, it was disposed. In fact, the communication of the clients to me at paragraph 30, my lord, the last paragraph which I have shown at
No,
page
no,
19.
you have to now bring all the facts before this court. Though e-court shows that 7/1/2017 it was disposed, and on the basis of that information received from you, from the e-court portal, you made a submission before
Well,
this court.
And in fact, my lord, to counter
My
this,
query is what actually happened on 1/7/2017? This you have to find out.
seven
You
was
can easily
from
find out from
the order sheet.
order sheets.
That I can.
Then
But if
only-
your lordship will kindly see page 19, the communication between the client and me.
No, that is the
There,
personal
there also they
communication.
have said that the local council informed them that it was disposed.
No, but actually what happened, what order court passed on that day? Whether it was not disposed and wrongly shown as disposed
That order of 7/1,
is relevant.
7/1/2007.
Yes.
I'll try. To get that.
In the meanwhile, we will issue notice
In the, and my lord, I have
in
an
this
interim
case
prayer.
without restoring.
I have an interim prayer in this interlocutory application. The proceeding may be kept.
No, 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 no.
Well, the issue which was challenged between the CRP is that, my lord, there was an arbitration agreement. Section 8 application was filed. The learned court below rejected that application on a ground that the dispute is not
No,
arbitrable.
we are, no. You have not brought all the facts before the court. What orders the trial court passed on 7 that is relevant in this
No,
case?
my submission before your lordship would be that my submission as that the matter has become infructuous was based on the court status. In fact, your lordship will kindly see. Para
Where
6
where
of
is
my
the trial court is at Mongoldoy,
Tezpur, my lord.
Tezpur.
Your lordship will kindly see para 6 of, that's my grounds of in this application.
Now, what is the status of the trial?
Trial, my lord, it is fixed on next 4/1/17, 4/1/2025, my lord, for submission of written statement. But I need not file written statement because this is an application, section 8 was rejected. And it's a settled proposition of law, my lord.
No. If interim stay is not granted,
I'll have to file my written statement, my lord, or it will proceed ex parte.
okay,
That will again bring me before your lordship for setting aside that ex parte order. Because section 8 says, my lord, before submission of
we are fixing it on 3rd of January
third of
without any stay.
Very-
3rd, Mr.
B question.
B. Kaushik, learned counsel for the applicant. This application, this interlocutory application has been registered on. No, this IS civil number 3 3611 has been registered on filing of an application under section 151 of the Code of Civil Procedure, 1908 by the petitioners, by the petitioner Messrs. Cotton County Retail Limited, praying for recalling of the order dated 31/7/2024, passed by this court in the Civil Division Petition number 400/2016. Learned counsel for the petitioner has submitted that the Civil Division Petition number 400/2016 was disposed of on the basis of submissions made by the counsel for the petitioner that the matter has become infructuous. It is submitted by learned counsel for the petitioner that the engaged counsel for the petitioner made the aforesaid submissions on the basis of an information which the petitioner got from the e-court portal, where it has been shown that the title suit number, what is the number?
Title suit number 30/.
Title suit number
2020.
30/2020 has been
30/20.
disposed of on 7/1/2017. Stop. However, later on, now whether it was disposed of on that day or not, this you,
It would not have been disposed of because there was a stay order operating.
oh yes. Learned counsel for the petitioner has also submitted, but this fact, this was known to you that,
No, my lord, what has happened, my lord? I was never in touch with the clients, my lord. My friend, my lord, who was on record with me, post Tatu, my lord, he died on 18/8/2022.
learned counsel for the petitioner submits that though the petitioner made submission on the basis of the learned counsel for the petitioner made submission on the basis of the information reflected in the e-court portal. However, later on, he came to know that the said suit was not disposed of on the said date, and hence he has prayed for revoking the order of disposal of the order dated, which order?
31/07/2024.
31/07/2020. Stop. It appears that the petitioner has not brought on record as to what order was passed on 7/1/2017 in title suit number 30/2012 on 37/2012, and on what basis the entry has been made in the e-court portal showing the same to be disposed of. Stop. Hence, the order passed on 7/1/2017 appears to be relevant in this case. Learned counsel for the petitioner submits that he would bring on record the order passed on 7/1/2017 by filing an additional affidavit of issue notice to the opposite parties. The petitioner shall take steps for issuance of notice to opposite parties by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 3rd of January 2025. Let this matter be listed again on
My
3rd
prayer
of,
for you.
not today.
On the next day. If your lordship is considering, my lord, I have,
No, on that day we will see what,
my lord will reflect that.
no reflection. What we will do on that day,
No, my lord will consider, my lord. My lord may
everything
case-
will be considered. Whatever prayer is made, we will consider everything, but no reflection. Finish.
Of the records though, my lord, in one matter, my lord, before Justice Kalyan Surana, there was a bail application wherein it was somehow noticed by the honorable court, my lord, that on the affidavit, while swearing, the deponent needs to give its mobile number. And it was found that the mobile number belonged to someone else and some false number was given. Even in such a, if I may say, it's a small matter, compared to what has happened in our case. Even in that case, the court has directed the registry to take appropriate steps. There are.
You give a copy of that order,
I
accordingly.
Grateful.